All right. Well, welcome to the Great Trials podcast. I am your host, Steve Lowry, here with Yvonne Godfrey. Yvonne, how are you doing in whatever day of quarantine this is?
I'm doing good. All the good snacks are gone.
Yeah.
So I only have the stuff I don't want to eat, which is probably for the best. But yeah, I mean, I can't complain seeing what other people are doing out there and, first responders, medical providers, grocery store workers, all that stuff. I'm like, I really can't complain about anything.
Yeah, I've heard a lot of stories about people who at work who aren't allowed to wear personal protective gear. And I just don't know how people do that nowadays.
Yeah, well, and then I think there's the other people that can wear it if they can find it. And
right.
You know.
It's crazy times, but
Yeah.
but thanks to Zoom and technology, we can still do our podcast.
Yeah, and actually, I can't remember if we said this in the last one we recorded, but it's really the same for us. It's probably the only thing that's remained exactly the same as how we do the podcast.
Right, exactly. I mean, we've been doing Zoom the whole time, and so as we were saying before, Yvonne, you and I had a leg up on everybody else in our office because we already knew what we were doing.
We already knew how to use Zoom. That's right.
Yeah. Well, I want to go ahead and introduce our guests today. So we have three fantastic lawyers from Bakersfield, California. So they're all the way on the other side of the country. But we've got here with us Daniel Rodriguez, Danay Gonzalez, and Chantal Trujillo, all from Rodriguez and Associates. And you can look them up at rodriguezlaw.net. That's rodriguezlaw.net. How are you guys doing?
We're doing fine, thank you. I walked into a grocery store this morning and I was reluctant. I hesitated about, I only had a bandana and I thought, a guy with a brown skin walking in with a bandana, that's not a good recipe. That's not a good formula.
I was telling my wife, I was like, this is a good time to be a Western bank robber right now.
Right.
Well, let me tell everybody about you guys and give a little bit of background so they can know who we're talking to. I'll start with you, Daniel. So Daniel, I was reading that you have a very interesting background. You started out as a child, as a migrant farm worker, moving between 4 different states and have held all kinds of jobs, including a dishwasher, sold encyclopedias, all before deciding to go to Cal Poly State University and get your engineering degree, and then move on to UCLA Law and get your law degree. Since then, you've just had a fantastic career as a lawyer and in the Bakersfield in California. And I should note that you are a teacher at Jerry Spence's Trial Lawyers College, which is very prestigious, and have been a super lawyer every year since 2009, and were voted as the best lawyer in Bakersfield in 2015. Oh, and I saw this in there too, and I wanted to ask you about it because I don't really understand the oil industry, but I saw that you were a roustabout. What's a roustabout?
Roustabout's just a fancy word for a laborer.
Okay.
You're at the bottom of the totem pole. That was one summer, and then the second summer working out there as an engineering major, oil companies back then wanted to hire people like myself. And then the following summer I worked as a mechanic, and a mechanic working on not little pistons like this on a car, but pistons on a steam engine that were about this big.
Oh, that's fascinating. Yeah, and when I saw roustabout, I never exactly knew what that was, so I'm glad I finally learned after all this time. Let me move on to Chantal. So Chantal is a native from Bakersfield, California. She's a graduate from the University of Texas, and then went to St. Mary's University School of Law. And Chantal, I understand that you're known for working late nights and extra hours in order to get just great verdicts for your client. And I also saw that you have a Yorkapoo named China.
Yes, and out of all the things that you said, the most important is the Yorkie poo. No, which actually she's upstairs right now.
Oh, she's in the office right now?
Yeah, I was like, oh, she's gonna make a special appearance.
Yeah.
No, I'm sorry, go ahead.
No, I was just going to say I'm working in my office, and my paralegal is downstairs with her dog here too. So I think everybody's taking this time to make sure they bring the whole family.
Yeah, exactly. You know, bond with the fur babies.
Absolutely.
I have never wanted a dog more than during this whole social isolation thing. I'm allergic, so I don't have one. But right now I feel like no, it's worth it. It's worth the allergies to just to have a dog in the house.
You have some socialization, some contact.
Exactly.
Yeah.
Well, and then Danay Gonzalez, we'll move on to you. And we were talking about this before. I am pronouncing it right. It's Danay, like what a judge might do. Is Danay?
Yes, that is correct. That's my name.
Yeah, and Danay, you were born in Bakersfield but grew up in Lamont. And I'm not familiar with the with the area out there, but I'm guessing that Lamont is close by to Bakersfield. Also went to UCLA. And then went to the Chapman University School of Law. And I understand that what you like to do on your own time is sing both English and Spanish ballads.
Yeah, so singing is my other calling, and I'm fortunate enough to continue singing here in Bakersfield. I have a couple of local commercials where I sing in them, and so I'm known as the singing lawyer.
Very nice, very nice.
Cool.
Well, maybe at the end, maybe we can get you to sing a little bit for us.
Oh my gosh.
I bet you didn't know you were going to be asked that.
No.
Steve, if I may to put it in context, when you said Danay grew up in Lamont, Lamont is about 3 miles from the labor camp that John Steinbeck wrote about in his Grapes of Wrath book.
Oh,
That's
wow.
an actual place. And it's an actual labor camp. By the way, I lived there as a kid part of the time because it was a labor camp.
Wow.
But if you're familiar with Grapes of Wrath, Lamont is 3 miles away from that labor camp.
Wow.
Yeah, no, I mean, speaking of Steinbeck, my daughter right now is reading Of Mice and Men for a class, so we were just talking about that.
Yeah.
Man, we've already covered so many fun facts. I don't even know if we need to talk about the case, except
Right, yeah, exactly.
of course we do, because I'm very excited to talk about this case.
Yeah, I think it's the first in the country and maybe only one that I've really heard of, but it involved a school shooting, a tragic school shooting out at Taft Union High School in Kern County, California. The name of the case is Bowe Cleveland versus Taft Union High School District, and it was tried. The shooting itself happened in January of 2013, but the case was tried in July of 2019 and resulted in a $3,800,000 verdict on behalf of Bowe Cleveland. And 54% of that was allocated to the school district, and I think the other percentage was allocated to the young man who shot him and his family. But just to give a brief overview of the facts, and I may have some of this wrong, so correct me where if you need to. But I understand. I think Bowe was a sophomore in high school, and the young man who shot him was also a sophomore. His name was Brian Oliver, and essentially there had been a sort of a history of Brian being bullied by various people, and I think there was some dispute over whether or not Bowe was involved in some of that. And then a number of reports from students, from teachers, and even from a parent I think I saw of activity that showed that he was threatening people. He talked many times about shooting people. Talked at one point, I think, was sort of bragging that he thought he could kill 50 people in the school when he was on a field trip. And that all of this was coming to the attention of the school, including the assistant principal and a counselor. And essentially, nothing was done about it. No action was taken by them. And then there was a couple of other issues, like, for instance, there were 43 cameras at the school that weren't being monitored. There was a gate that should have been locked, and you showed at trial that had they been watching the cameras, they would have seen Mr. Oliver come through the gate and could have
Locked
sounded
down
an
the school.
alarm. Yeah,
Yeah.
could have locked down the school and sounded an alarm at that point. But since nobody was monitoring it, he was able to walk into the classroom where Bowe Cleveland was shot, and shot Bowe Cleveland with a 12 gauge shotgun in the chest. Bowe miraculously survived, and I think he was Mr. Oliver was trying to at least shoot one other student, and I have his name somewhere, but I don't know what I did with it. But wasn't able to shoot that student. So Bowe was the only one who got shot and was able to survive, but with just some horrific injuries. He got shot in the chest and had numerous surgical procedures and just a tremendous amount of mental and physical pain and suffering. And I know that's a very brief overview of the facts of the case, but I tell me what I missed there, and I'm sure a lot.
No, you got the gist of it. This shooting took place 27 days after Sandy Hook. And why is that relevant? It's relevant because the school was on even more notice, as were all school districts across the country. And this shooting took place about 11 years after Columbine. Why is that important? Because after Columbine, most school districts across the country, including Taft Union High School, had set into place a protocol known as threat assessment, a threat assessment system that was set up. It was a very good system. The problem with it is the red flags were identified that you talked about these numerous threats made by this kid who eventually shot Bowe, but they were ignored. So you can have the best system in place ever, but it's not worth a darn if you decide not to follow it and to ignore all the red flags.
Yeah, and I saw, I didn't realize that it was 27 days after Sandy Hook, but I saw that on the day that this happened, they were actually doing an active shooter drill. And, you know, just by happenstance, that it happened to be the same day that Mr. Oliver came in and shot Bowe Cleveland.
Yeah, interestingly enough, like you mentioned, before school opened for the students, the staff got there early and they were going through a drill on what to do if there was an active shooter, including sounding an alarm. But you're not going to sound an alarm if nobody's watching any of the 43 cameras in place put there for the purpose of preventing such a thing from happening.
Yeah, I thought it was interesting that it seemed like in the opening that one of the things that the attorneys for the school district said was that they almost pointed out, it was weird. They were like talking about the number of shooting statistics or how common school shootings were, almost like that was a defense versus arguably making this more foreseeable. I was very confused by that.
Yeah,
you're right. We were sitting there and we're listening to the opening statement, and I'm thinking to myself, wait a minute, is he representing the school district or us, at least at that, in that piece of
Right.
his opening? It didn't make much sense. I don't know what he was trying to do, if he was trying to normalize it and say, hey, things like this happen no matter what you do, because there's so many of them that happen. I really don't know the reason. That's the only thing I could come up with.
Yeah, and there's a couple of other things that I thought were interesting, and I wasn't sure where he was going with that on the defense, but the fact that he was trying to point out that this was a targeted shooting, and maybe this was based on something that one of his experts was going to say later in the case, but I wasn't sure why that would be that relevant if they had they obviously had prior knowledge that this person had made threats. They had the ability to stop him before he got into the school. So what would it matter if it was a targeted shooting? I guess unless he was going to put up evidence that no matter what they did, that he was going to find some way in order to shoot Bowe Cleveland.
I think Chantal can speak to that.
Sure. Yeah, one of the big things, and you're right, they had an expert that kind of touched on that. That was their focus. One of the big things is that they wanted to push off as much fault as possible onto the shooter, right? And so the more they made it about a targeted shooting, the more focus that they were able to put onto the shooter. And then to add more on top of it was the school district kind of took this approach that, yeah, we had this notice, but Bowe Cleveland was never identified specifically. So, and because this was a targeted shooting specifically against Bowe, we couldn't have known. It was a really weird strategy that didn't make much sense to us. And I don't think it made much sense to the jury. So,
yeah,
May
I
say
had,
something about that.
Yeah.
The challenge in this case was every trial is a drama, which means what? It's a story. And every good story has what? It has a protagonist and an antagonist, a hero and a villain. The villain here, obviously the school district wanted to say the villain was the obvious one, the shooter who got convicted and is sitting in prison and going to serve, I forget now, 27 years to life or something like that.
Mhm.
So he was the easy guy to make the villain. So our job was to take that focus away from the shooter, not what happened that day, because the defense always wants to talk about what happened. What was the situation, the shooting in this case? Well, if we talk about that, then we were scrutinizing all the choices made by that person. What we wanted to do was to start the story earlier. Everybody knew what happened. The shooting happened. The more interesting question and the better question for us is, why did it happen? What was the motive? What could the school district, that way we get to scrutinize the choices made by the school district. For 10 months, they ignored numerous red flags. This kid, this eventual shooter saying, I'm gonna blow up the auditorium. I'm gonna shoot 50 kids. I'm gonna poison kids. I'm gonna do this. He wrote a story about it. All these things that came to the attention of the school district. So our challenge was to take the jurors' attention and put it earlier, much earlier, 10 months before the shooting happened. Because that way, when you tell the story, it's now we're looking at the motivation for this. And then what was the motivation? And I told the jury, we'll never know why it is that the administrators chose to ignore all these things. Was it because they were more interested in the school image, in their jobs? They were just sloppy, they were just lazy, or were they indifferent? That's probably, we don't have to come up with a motive, but it's up to you folks to come up with that. So that's what's a challenge in the case, is to scrutinize, because there's a psychological principle that I've never seen in a book, but I'm sure it came from somewhere. We are more critical of that which we are most familiar with. We are more critical of that which we are most familiar with. So if your story is all about the shooter, we're going to be scrutinizing his choices. But if our story is about the school administrators and the choices they made, so now the narrative spotlight is on the choices of the school district, of the administrators. So that was what we were trying to do. We spent most of our time talking about the school, the information they had, what they did with the information, their ultimate choices, and why they chose to ignore all that.
Yeah.
I thought your opening was very effective in framing the story that way, to the point that by the time that the defense lawyer started his opening for the school, you know, what it seemed like one of the things that he went into very early on was how quickly the school responded to the shooting basically after it had started. But you had already framed it as these months leading up to the shooting, that seemed very obviously sort of not the point and not the problem, because you had already framed the story around what happened leading up to that. And I think the way that you laid out, I was shocked, because I think sometimes you hear about these school shootings and they are these loners who aren't talking to people at school, who aren't doing these things at school, and they have this other secret life that people don't know about. I was shocked by how much evidence you had of students reporting things to people in school, and how many of these threats or statements were made and actions were done at school or on school trips. I mean, it's just the stuff that blows your mind. Like the student, I know there was a female student who had reported thinking things were dangerous at least once, and actually did the thing that's pretty hard for a high schooler to do, and it basically went nowhere.
And that's called leakage. In almost 100% of all school shootings, the eventual shooter has leaked his intentions before, because it is what, Danay? A cry for help.
Oh,
Remember?
yeah.
Right.
And the reason I asked
For
Danay,
attention.
she's the one that came up with that idea.
Right.
It was a cry for help.
Yeah.
Yeah.
Yeah, it seemed to me like it's a cry for help, a cry for attention. That's why you keep talking about it over and over. And then
And speaking of a cry for help, Danay, do you remember the answer that the assistant principal gave in the deposition when she was asked about whether or not it was a cry for help, which she told us?
She said she didn't think it was a cry for help at all.
I don't believe in that, she said.
She didn't believe in
Yeah.
it.
She said, I think I don't care for that word.
Yes,
Huh.
yes, specifically.
Yeah.
I don't care for that word.
that's
Play
such
that
an
video clip, by the way.
yeah, that's such an odd response for somebody who spends their life working with teenagers. Yeah, that can't be the first time they've seen actions like that.
And,
Well,
oh, I'm sorry.
no, you go ahead, Chantal.
Well, so I was going to say, I think another interesting point was, obviously they wanted to put as much fault on the Brian Oliver, the shooter, and then also his mom. And one way they were trying to do that was that they were saying, oh, well, she should have never allowed the shotgun in the house. And she should have known that her son was, dangerous or things like that. Well, one huge piece of evidence that we had was there was the shooter, Brian Oliver, the student, was a special education student. And so that required an IEP plan to be done for him.
And IEP is what?
Individualized education plan. Thank you. And so in there, you had these, well, let me back up. You had all these reports on that field trip, right? From the students and staff members. Then they do an IEP plan about 12 days later that they give to the mom. And in that IEP plan, it says emotional, social concerns. Nothing. Brian is a great student. He interacts well with his peers. This is not an area of concern.
This is 12 days after the shooter on the school bus has threatened to shoot kids. And 12 days later, they write a report saying he has no social concerns.
Yeah,
Yeah.
I mean that's just
He's
crazy.
perfectly adjusted.
And is this before or after? I know there was like an incident where he was kind of like sort of like miming or stabbing somebody with a pencil. And
That was before, right?
okay.
And this was right afterwards.
Oh, okay.
Yeah, it
Okay.
was like all kind of, and it was right afterwards. And people who did the IEP one of them was the counselor, the school psychologist, and he was well aware of all of those reports, including that stabbing gesture one that was actually made directly to him. And so the mom, rightfully so, takes the stand and she's like, they told me he was good. Like, I actually thought everything was okay. But, what made you think that? Well, because there's this plan and I read it and I signed it. And so I had no reason to believe that there was anything going on.
Yeah, I thought that when I was reading the opening of the defense, I thought that he was, I guess, trying to react to your opening, Daniel, and you had sort of set it up nicely for him to have to explain away a lot of things. But for instance, they were taking the position. They were essentially trying to say that this is all the shooter, this is all Mr. Oliver's fault and his family's fault. But at the same time, he's giving all this evidence of what great strides he was making and what a great kid he was. And it was like, well, how are you, blaming him at the same time that you're saying that he was doing great? And then the other part, when I saw him doing this, he was sort of going through each one of the red flags that you had raised and then was giving a different explanation for it. And I was just thinking to myself that whenever you're in that position where you're just explaining away red flag after red flag, that's just never a good position to be in the courtroom.
We have a saying, Lucy, if you're explaining, you're losing.
That's right. That's right.
I like that.
Yeah, exactly. Well, talk a little bit about, so you had, it seemed pretty good evidence that Bowe was a well-liked student, seemed to be popular with everybody, and that he wasn't a bully or hadn't been involved in bullying of Brian Oliver. but there had been some statements, I think, by Brian Oliver and by his mother at his criminal trial, that he had been involved in the bullying, and then the fact that he basically was targeted, by Brian Oliver, I guess in on one level might suggest that he may have been involved in some bullying. Talk about how you approach that issue, because I mean, it's not a justification for, what happened, but it certainly seems to be an attempt to maybe make it sound like Bowe had it coming or something like that.
No, exactly. You see, on an intellectual level, we all say things like, well, that wouldn't justify, but, then the words come, but he did bully him. At least that was the contention of the defense. And it was disappointing, for us at least, that the trial judge said, we objected, said, what's the relevancy of that if the defense has already taken the position that there's no contributory negligence on the part of Bowe? If there is no contention that he contributed to his own situation, why is this relevant? None of this should be coming into evidence, because a lot of it's hearsay. For example, the mom, when you drill down on her testimony, it was based on hearsay, so it should be tossed out. So we went through this, and the judge overruled our objection and said, no, I'm going to allow the defense to put on this testimony. And we're scratching our heads and but wait a minute, what's the relevance if there is no contention of contributory negligence?
Right.
And then it has no probative value. It only has prejudicial value. So why is it coming? That's one of our points on appeal, that should never have come in. Okay. And then at the end of the case, the defense gets up and they change their mind, and they're telling the judge, now they want Bowe Cleveland's name to appear on the special verdict form for allocation or division of fault. Luckily, the judge shut that down, because we objected. Wait a minute. All along, he's been saying that he got up and told the jury that Bowe's a very nice kid, and I call it the bless her heart in the South.
Yeah, that's right.
Yeah.
She's a really nice gal, bless her heart, but that kind of, and then the judge sustained our objection and said, no, I'm not going to put Bowe Cleveland. But by then the damage had been done.
Right.
Even though when you drill down on each of these witnesses who said these things, there's only 2 or 3 of them, there was no basis for it. But emotionally, there's an intellectual and there's an emotional. I think in the back of most people's head, Bowe is a big kid.
Right.
Bowe is like 6'3", 6'4", 6'5". At the time, he was like 300 pounds. In fact, that was one of the reasons he wasn't killed.
Yeah, he lived.
Can you imagine getting shot almost point blank with a 12-gauge shotgun and living? The only way he survived was because he had quite frankly, he had fat on his chest, So that helped him survive. But Bowe was a big kid, and at the time, Brian Oliver looked like a mousy little kid. Although when he testified in this trial by way of a videotape deposition, I will tell you that he looked like a grown man, and he had a tooth missing. He had a tooth knocked out by an inmate because, of this happening. He looked, and I'll say it right now, he looked like a serial killer.
Yeah.
He had a beard, and not to say that people with beards all are serial killers.
Yeah, no. Go. Wait a minute now. Hold on.
But so he and the way he spoke, and the way he looked, and it didn't help that he was in an orange jumpsuit with handcuffs. So he looked like a villain.
Yeah. So I guess so once the judge denied your motion to exclude that, you basically had to turn around and just hit it head on, and I've always talked a lot about at trial that you got to take your weaknesses and just hit them head on, and I thought you did a great job of that in hitting the fact that there were going to be some people who were going to say that Bowe had bullied him, but there were going to be a lot of people who were going to say that Bowe was just a very nice kid, sort of a big teddy bear and well liked. and and you got to look at the motivations of the people who are making those claims. So it was a nice job of adapting to what the trial judge had ruled.
I'm guessing maybe one of the other issues maybe on appeal might be this whole issue with the officer who didn't show up that day for work. Can you talk a little bit about what happened that day?
Well, let's set. Just so
Okay.
Our listeners know. So there was the school had contracted with the city for some police presence, and so they were basically supposed to have an officer. I think it was called an SRO. Walk around the campus and provide some security. And then for some reason that particular day, the officer did not show up, and so I kept checking the apportionment, on the verdict form, and I'm like, well, why is the officer not on here if they're making some claim? But yeah, so talk. I just want to make sure our listeners knew what we were talking about. So the officer who was supposed to be there for some reason didn't show up that day.
Yes. And so this particular day, was in January, right? And it was cold. The officer, the SRO, which stands for School Resource Officer, most high schools have them. He lived out in Fraser Park, which is kind of like a mountainous area. And so he had actually been snowed in that day.
Okay.
And so that's why he wasn't present. And they fought tooth and nail to get him on the verdict form. That was a daily battle to keep the city of the police department off the verdict form because they wanted him on there so badly. And
but here's the legal reasoning why we were able to keep him on. In California, at least, there's a doctrine of non-delegable duty. A school district, because students are a special class, the school district owes a duty to provide a safe place for studying, for education. And it is non-delegable. That means you cannot delegate it away. You can't say, oh, we're going to contract with somebody else, namely the police force, and give them that duty. So the judge understood that. But then when I said, Judge, since they can't be on the verdict form because it's non-delegable duty, and thank you for getting that reasoning right, why is it relevant then? That shouldn't be coming into evidence.
Right.
It's not relevant if ultimately the jurors are not going to be passing judgment on the conduct or misconduct of the school resource officer for not showing up on time. Why are we even talking about it? Why are we allowing evidence, testimony in that regard?
Right.
And the judge looked at me and said, I'm going to allow it. Despite his ruling. So anyway, as you said, that's going to be another point on appeal that we're going to argue about. That shouldn't have come into evidence. It's non-delegable duty. The trial court got it correct, but then turned around and allowed testimony regarding that issue to come in.
Right. And I mean, and it seemed to me to be damaging. I mean, obviously you all got a terrific result, but it seemed to me to be damaging because it allowed them to act like it was totally somebody else's responsibility who had shirked that responsibility. And it was not the school, it was not the school's fault or responsibility at all.
Right. Yeah. And one thing that I think is also interesting on that point is that school resource officer, he had just started working there that school year, right? So the 2012-2013 school year. The question is, did he know anything about Brian Oliver? Did he know anything about the warnings, that the red flags? Did the principal or the assistant principal ever tell him? Because he was supposed to be part of the threat assessment team. He was never told anything. He's like, I didn't even know who this kid was. They kept me in the dark about it. And so then the question is, like, if they don't feel like they need to share it with him, why does it matter?
Just to be clear on that point, the threat assessment team is made up of 4 individuals when they do a threat assessment and evaluate what they're supposed to do when some kid makes a threat. And that is the school administrator, which in this case was the assistant principal, school resource officer, the school psychologist, and the guidance counselor. And they're supposed to communicate with one another. Our point was this school resource officer who had been there on the job since the fall, about a few months before the shooting took place, were you ever given any information of any of these threats made by the shooter, by Byron Oliver, before the shooting? Not one bit of information was ever given to him. So that was part of our contention was, wait a minute, they have this great protocol in place, this system in place, but you're failing at so many levels in this system. You're not even communicating.
Mm-hmm.
The left hand doesn't know what the right hand is doing.
Right. Yeah, and they, you know, part of the defense in the case was, you know, you're dealing with 900 teenagers. They're going through all kinds of you know, various problems, breaking up with boyfriends, girlfriends, and, you know, and they say stuff and they get influenced by each other. And so it's a very, you know, difficult situation to manage, you know, and I thought you all did a really good job of addressing that, but talk a little bit about how you do address that issue, because it, you know, I could see a jury, you know, saying, yeah, you know what, this isn't an easy job. And, you know, how do you know you can trust the, you know, some, what somebody's saying, that they might just be bragging just to be bragging and not be a true threat?
And related to that, looped into that, to address the thought I think that some jurors would have, or at least potential jurors, that this is too much to put on schools, or that this is the responsibility of parents or families.
You know, we did a number of focus groups. We did a ton of focus groups. And that was one sentiment that was running through each one of these focus groups. Like, how do you control these kids? I mean, we as parents can't control oftentimes our kids that we have at home. And we expect this handful of teachers and administrators to keep a lid on the hormones running wild of 900 separate little starter humans. You know?
Right, yeah.
You know, so yes, and they really harped on that.
Mm-hmm.
You know, it's like, and their experts talked about that. It's like, hey, how do you know when they're just joking? How do you, people, an idle threat, something said in jest, something said in the heat of the moment. If we were to react to every one of these situations, we wouldn't have enough manpower. We'd have to assign 1 or 2 adults to each individual student. That's 1,800 administrators, you know, something like that is what they were trying to argue. And it was very effective. So we had to deal with that. And the way we dealt with that is we had to keeping the focus on, it wasn't one time, it wasn't 2 times, it wasn't 900 students. It was only 1 student making over 10 months, a whole span of time, making all kinds of horrendous threats. I'm going to blow up the school auditorium. I'm going to bring an automatic weapon to school and shoot 50 people. I'm going to do this. I'm going to do that. Just on and on. And how did the school react? One of the things was the school psychologist met with this shooter and said to, and one of his recommendations was he recommended to him to read some books. 2 books.
Yeah.
What were those 2 books? They were How to Be a Serial Killer,
What?
a profile of a serial killer, and had to do with maim and shooting and mass shooting and the psychology of these serial killers.
Oh my
So
goodness.
we had a field day on cross-examination
Oh my God.
of the school psychologist for that.
Well, and you know, and one thing I was thinking as I was reading this is because it seemed there was this issue of whether or not he had a hit list, and that had apparently sort of hit the rumor mill for the high school and the surrounding high schools, because there's a bunch of tweets about it, and I think even a parent called up and said, "I heard my child is on this hit list." So on the one hand, you know, it almost seemed like everybody in the school thought that he was capable of doing something really dangerous, and were talking about it with each other, but yet the school didn't seem to think that. So I thought that worked well in your favor on that issue.
Yeah, Danay, can you talk about how the parent that came in to testify about his concern for his son?
Right. So we had a parent come into court and testify, and basically what he told the jury that he expressed his concerns to the school, and he was really afraid for his son. And despite that, he was told not to call the police. He was told that the school would take care of it, and yet nothing was done. He wasn't taken seriously. And so it was really upsetting to him because it continued on. And then when all of this came out, it was just that fear grew. It was a growing fear that a lot of the students and the parents were experiencing during, like, in between that time.
Yeah, that was shocking to me. Is that the same parent who he had coached one of the shooter's brothers in Little League and was like, I will go talk to his mom about it, and the school told him, don't do that. Like, we've got it under control.
Yes, it's that exact same parent. He was trying to take the approach of, how can I help this situation? What can we do to, help the situation out? And he was discouraged from doing anything.
Can I go back to a point?
Yeah.
Here's what I played for let's see, can you see this?
Hold it up a little bit.
What kind of books did the school psychologist give to Brian Oliver to read? And it was Mindhunter and The Anatomy of Motive, both having to do with serial killing.
Right.
This is one of the exhibits we used in closing argument. We weren't allowed to use any demonstratives during the opening.
And I think it was helpful that I think Mindhunter was on Netflix at the time.
Yeah.
Yeah.
Punctures were aware of that.
Yeah.
So I have to, not that it matters, but I have to know, what was the explanation for why those would be good books for him to read?
Yeah.
I don't remember. I cross-examined the school psychologist, and quite frankly, I was trying to keep a straight face because some of the answers she was giving, I wanted to be respectful, and I know he was trying to be sincere, or at least I thought he was trying to be sincere. And I don't remember his answer because when I do cross-examination, I'm just telling a story, and I don't really care what the answer the witness is giving. I'm just telling a story, and I'm creating a yes set or a no set as the case calls for. And I really don't listen to their answers.
I think from what I can remember, because I was like, I wonder what he's going to say to this. From what I remember, I think he said something like, well, he just seemed really to be interested in murders and killings. And I thought this would get him on the right track.
Right. What?
And I'm like,
the right track for what?
Exactly. I was like, what's the right track? I guess in one way it was,
Yeah. I don't know. I mean, and I think that the thing was, my understanding based on the opening was that, and I'm not sure where this fell into the timeline, but at one point when it was sort of pointed out somehow to administration about him making threats and stuff and struggling, that he wasn't required to do counseling or anything, but that he was supposed to check in with the school psychologist if he saw him in the hallway, say hi or something.
That was a dilemma for the defense. See, they were taking the position that the school psychologist, because he was licensed by the state of California, he would be considered a medical provider. And therefore he didn't,
he was immune.
He was immune. Okay. Right. So, but they were walking this fine line because if they said that, so he kept saying, I never treated him. I never counseled him. I just had him check in with me.
Okay. Got it.
So they were walking this fine line between I counseled him, I gave him therapy, and I didn't.
Right. Got it.
Waffling, So my thing was, you can't have your cake and eat it too. You got to fish or cut bait.
Right. Right.
Or you weren't, and they could never make up their mind, and so they were just waffling. But the jury, I think, didn't really care for the school psychologist by the time he got off the witness stand.
Yeah. I want to go back for a second to your focus groups, because one thing I was thinking about is that, in a case like this, there might be, what we would call a jury bias for teachers and school administrators and people who are doing the best they can. And I wonder did you see that in your focus groups, and how did you choose to address that?
Yes, we definitely saw that bias. So a jury is all about sociometry. Okay, it's what we call tribes. Okay, so at the Trial Lawyers College, one of the things that we teach is that we say, look, when you start out as a lawyer in the case, you are not a member of the tribe, the jury tribe. You're an outsider. The school teachers are part of the tribe. So a tribal member will never kill another tribal member. So first, if that tribal member, if that person is a part of the tribe, first you got to drive them out of the tribe, and then it's okay to kill them. I'm speaking metaphorically. You drive them out of the tribe, and then it's okay to kill them. So how do you do that? So if it's a 1983 civil excessive force case, for example, I've tried a number of those, is a police officer, the person you're suing is a member of the tribe. So how do you drive him out? By giving facts that he is a rogue officer. He doesn't fit into the stereotype of what expectations we have of a police officer. Same thing with school administrators. They start off as a member of the tribe, but as an administrator, the expectations we have of an administrator is that they're supposed to do their job, right? And part of the job is when you have overwhelming number of red flags, is you do something about it.
Right.
You have all these rules and protocol in place and you don't do it. So you can't just get up and say, this person's a bad person. You have to give facts. You can't use conclusionary language. You have to give facts without ever using I don't like adverbs. So I rarely use adverbs when I'm introducing a character, especially when I'm introducing the villain in my story. I stay away from adverbs. It's like, I don't say this person quickly moved out of the way. I say he jumped out of the way. I think adverbs is what I try to teach folks around me is adverbs is the lazy writer's word. Don't use adverbs. So here we created to combat this bias is just to give them facts when I was introducing the villain by his or her actions. It just so happens it was a school administrator. So now the idea was with these facts, this story, I have driven this school administrator out of the tribe, and now it's okay to kill him.
Yeah.
I also think that it was helpful that you also have school administrators like librarians or computer techs that were also expressing their fears. And so it's almost like a betrayal to their own, family, right. In a sense, their students, the parents, and now even the staff. So.
Right. And I thought one thing, when you laid out sort of the 5 issues for the case and several of them were basically things that wouldn't have been that hard to do, like just pass along the information you had to law enforcement or pass along the information you had to the other teachers or to the parents, and so you're, not only are you showing that they had a lot of information, but that it really wouldn't have taken that much for them to make a difference here and to stop this from happening if they had just, passed the information along.
Right. And so when they fail to do that, how do you frame that? Do you frame it as a mistake or as a betrayal? What do we do generally with people who make mistakes as a society?
Give them a pass.
Forgive them,
yeah.
Right? What do we do with people who generally betray us? We don't.
we kick them out of the tribe.
Right. So what is, there's 3 elements to a betrayal. One is that you create a trusted relationship. You show there's a trusted relationship. 2, you show there's a violation of that trusted relationship. And the third reason is for the wrong reason. So here, right. The school administrators, there was a trusted relationship between the parents, other teachers who looked to the school for protection. They violated that trust by not, and for what reason? Was there a good reason for them to withhold that information? There wasn't. So that was part of the betrayal story, to drive the school administrator out of the tribe. I hope that makes sense.
Yeah, it does. That's great.
I like it a lot. You also said one other thing that I've had to deal with this in trials before, and it definitely can make for an interesting opening. But you said the judge didn't allow you to use any demonstratives in your opening. Is that something that's unique to California, or is this just this particular judge?
This particular judge, I'd say about more than 50% of the judges in California now allow demonstratives in the opening, and you have a minority not allowing it. And in this case, this particular judge, for whatever reason, and he was overall a good judge, but I was kind of ready for that because when I practiced my opening statement, I practiced it two ways. One with demonstratives, and just in case I'm not allowed to use them, then I switch over. So here I became a human timeline. So in the courtroom, there was a place that I would point to, and that was, 10 months before. And then I move over a month and I would physically anchor that position and say, here's what happened. And I go into a story and then I point down the timeline and say, and then a month later, and I move over there and finally I get to the day of the shooting. So, and then whenever I would refer to those events chronologically, whatever time it was, I would move to that point in the courtroom that I had created as a milestone in my timeline. So I created a human timeline and it worked out for us.
Yeah, yeah.
I like that a lot because then without being able to use other visuals, you're still creating a visual for jurors who learn that way, who will remember, the different places you were standing and what you were saying when you were in that spot.
And Yvonne, the proof is in the pudding. I would refer to a time, and before I would even go over there, I'd see the jurors move over to the
Right,
spot that I had marked as that event.
That's great. That is great. I like that a lot. Well, related to things that are typical in California, it looked like this case was bifurcated liability and damages. Is that also typical in California?
I'd say at least, what do you say, Chantal? 2/3 of the time?
Yeah.
They'll grant the motion.
Right, exactly. Especially when there's a lot of witnesses for liability that you can separate from the damages. And here, we didn't really have a good argument that they should, that bifurcation should not be allowed.
Gotcha.
It's discretionary on the part of the trial court.
Okay.
So as you know, on appeal, abuse of discretion is a pretty high standard to show, and the judges all know that. So they're hoping, oh, this is such a tough case. If I bifurcate it and the plaintiff loses on the liability phase, hey, it went from an 8-week trial to a 4-week trial. Hey,
Right, yeah.
Right.
Yeah.
I can go fishing.
Right.
Trial lasts an extra week.
But one thing I wanted to ask, I noticed that during the opening you didn't have Bowe in the courtroom, and did you have him out of the courtroom for most of the trial? And I didn't actually see, did he testify, and how did he do if he did?
Well, I have to say, yes, we did not. I think we had him there for voir dire for the first day just to introduce him, and then we didn't have him there. And I explained to the jurors that the reason for that was that the mental health professionals, his therapist, said it wasn't good for him to hear these gory details. Okay. So he wasn't there until he testified. As far as his testimony, I have to tell you that Chantal handled his direct, and she hit it out of the ballpark. You could hear a pin drop while he was testifying on direct. She did a marvelous job with him. I think the jurors connected with Bowe. He's such a good kid. He's a good human being. And Chantal had her work cut out for her because she had to undo the insinuations and outright accusations that Bowe had bullied this boy, the shooter, when he hadn't. So the jurors already had that, whirling around in their minds about that. And I think Chantal did a magnificent job.
Thank you.
Chantal, can you talk a little bit about how you approached that direct, both in terms of preparing for it and what you wanted to accomplish? Because I think it's hard, even with a client who hasn't been through such a traumatic experience. I think it's sometimes just hard for them to open up on the stand. But in this particular situation, with what Bowe had gone through, I can't even imagine. So I'm really interested in hearing how you approached it.
That's a good question. I think what really helped here is that Bowe and I had a really good relationship. It had been years, right, from the date of the incident to the trial. And so we became friends. And so I was fortunate enough to have his trust already, and we kind of vibed. We did vibe. We're still friends. As for undoing those thoughts and being, conscious of that, I told him, I was like, Bowe, this is what's going on. this is what they feel. We need to address this. And he's, okay, let's do this. Let's figure out how we do it together. So one of the ways that that Daniel had done in advance was we would show Bowe doing nice things for other people, right? And that way they kind of saw him already as this kind, gentle person. Now, as for the bullying issue, I think there was the one part about where Brian, the shooter, had said that Bowe bullied him and I had chased him up the stairs. So I addressed that issue flat out because I think the jury wanted to hear that, right? Like, what was going on there? And Bowe was like, I did, we were going from class to class and I was calling out his name, but I was like going to give him a hug, which there had already been testimony beforehand that Bowe would do that. He would give hugs to people, and he had been described as a big teddy bear by the staff and by other students. So I think it kind of fit, and Bowe, he is, I don't know how to say this, he can be a comic sometimes. Right. And there were a couple occasions where the judge had forgot to turn the microphone on, okay, in the courtroom. And Bowe just, it was very cute because he's like, Judge, I think this is not on. I think this is off. And it just lightened the mood with the jury. And
the jury laughed.
Yeah. And so,
that's great.
Yeah.
They like him if that happens.
Yeah.
Exactly. Can I speak to that point, please?
Yeah.
When you're writing a story, you're a Hollywood screenwriter. The Hollywood screenwriters that are not very good will use conclusionary language and show the villain and say, this is the villain. The good screenwriters show the character doing something bad and lets the audience come to that conclusion. Vice versa, if you start off with a character and you show him, let me give you an example. If the movie starts out with this character walking out of his apartment and walking down the steps, and there's some kittens there, and he kicks the kitten, and the kitten splatters against the wall. Oh, jeez. You're going to hate him, okay? He's the villain. Nobody called him the villain. He wasn't wearing a black hat. He didn't have the word villain tattooed on his chest. You hate him. But if a story starts out him walking out of his apartment, the door, he turns around, and there's a little kitten there, and it's about to walk out into the street, and here comes a transit bus, and he jumps and he picks up the kitten and saves the kitten. That's the hero. You didn't call him a hero. You didn't call him a good guy. You showed facts. So when you can show your character being in the service of others in your opening statement or through the testimony of others because you don't want your client taking or your witness taking the stand and say, are you a good guy? You need to talk about all the good things you do for people. That's self-serving, obviously. So you do it through other witnesses and other evidence, but you show your character being in the service, being in the service of others. Then your audience is going to like him and identify him as a hero without you ever having to say, this guy is a stand-up kind of guy. And you're going to hear that he's the greatest thing since sliced bread, which is unfortunately what a lot of us lawyers do.
Right.
That's not going to cut it. You got to show facts. Just a little vignette, a little story, when you introduce your character, will go a long ways.
Mm-hmm. Yeah, absolutely. I do want to move on and make sure we get a chance to talk about damages. So as Yvonne already pointed out, the case was bifurcated between the liability phase, which sounded like it took about 3 weeks, and then the damages phase. And I saw in your opening, Daniel, you did a really nice job of just putting yourself sort of in the shoes of Bowe, after he's been shot, and talk about that a little bit and about, how you showed the damages in this case and how you conveyed that to the jury in your opening and closing.
It kind of goes back to what I just said a few minutes ago, and that is you want the jurors to like your client. You want a likable hero, but here's the key. You want a likable but flawed hero. Yeah. Okay? Because if he's perfect, he's boring and he's not believable. So if you only put evidence that your client is perfect, it's going to be boring and nobody's going to believe you. And by the way, the defense will always attack your client. So you're always going to have a flaw here, but embrace it.
Right.
Right.
Okay? Use that as part of your introduction, your part of the case when you're talking about your client, and show him to be vulnerable. Then what I do is oftentimes the precipitating event. When I say precipitate, not the turn in the story structure, but what happens, the actual event. Oftentimes what I do is I reverse roles and I play the scene out in the courtroom. I use body language and I use words. And if you look at, I hate to look at my opening statements because then I used the wrong grammar.
Yeah.
Oh, yeah.
But you had to be there, okay? You had to be there.
Yeah.
So the pauses and I reverse roles with my client, and I work out the scene in the courtroom. I decide, who am I going to animate? Is it my client, the plaintiff? Is it the defendant? Is it the bullets? Because it doesn't have to be a human being. It can be an inanimate object. I become the inanimate object. And I speak first person and present tense. Because when you do that, when you tell a story, not in the past tense, not in the third person, but in the first person and present tense, it brings the scene alive. And now you have the jurors in the scene with you, feeling what the character is feeling. So that's what we try to do. We try to take that scene and bring it to life in the courtroom without using any props, without using any demonstrative evidence. And you map out the scene. You put the school desk, you put the shotgun, you put, all of that. You become those characters, or there's more than one character. And you go through that. And again, the secret is first person, present tense. If you tell the story that way, people will remember it. Again, people don't remember what you tell them. People remember how you made them feel.
Yeah.
I do think that was effective, even reading it, because I don't know if you've read it, but obviously I did. And I think that was effective, even reading it in first person, reading it that way was a lot easier to engage and imagine.
Thank you.
Yeah.
It worked.
Well, and just the tremendous amount of surgeries that Bowe went through. I think he had 31 medical procedures, and then and was on 33 different types of medications, and then just sort of describing how, when you get shot by all of these pellets, how they, basically the process of getting those out, you can't just go in and take them out quickly. Some of them have to work their way out. Some of them will never come out, and just how difficult that is. And then when we're talking about the fact that he was able to get a job, but he would have to start out his day by taking 2,000 milligrams of ibuprofen,
Right.
which is certainly, I hate to say it, but it's certainly going to do damage to his liver and kidneys. I mean, that's just a huge amount of ibuprofen.
But he didn't have much choice, right?
Right.
He could either stay home and feel sorry for himself, or go out and work and try to have some meaning to your life. Yeah,
absolutely.
Just out of curiosity, when y'all approach a trial, obviously you all know your case very well, but I'm curious how, when you're getting close to trial and when you're in trial, if there's a specific way y'all like to divide up the work or the witnesses, or whether you just all work on everything and kind of decide some of it as you go. Because we do it, I think, depending on our trial team, we do it a few different ways. And of course, everybody knows the case, but there's some things that are everybody's sort of job.
Yeah.
Well, let me speak to that. First of all, in this case, there were 96 depositions. 96 depositions.
Wow.
I was in one of them.
Wow.
Danay and Chantal will outwork 5 lawyers, each one of them. Okay?
That's amazing.
They knew the case inside out. I always tell people, my job here at the firm is I'm a figurehead. They just prop me up in front of the jury and I tell them the story. But they're the ones that do all the heavy lifting They're the ones that do all the motions. They're the ones that, they really do a magnificent job. So when we divide up the work, they do the hard work. They do all the witnesses, all the depositions, all the pretrial stuff, all that. Danay can read Chantal's mind and my mind in trial.
We have this weird bond now. Where it's like, I know what he needs. I know what's coming.
I
Yeah.
walk back to the counsel table to look for an exhibit, and when I walk back there, Danay hands it to me without me
Yeah.
asking.
Oh yeah.
And so what we do is we think about the strengths and weaknesses of the witnesses and the strengths and weaknesses of us, because we have weak points, okay? And so we decide, okay, for example, I thought in this case, Chantal had just a very close relationship with Bowe. And no amount of work on my part was ever going to replace that. I was never going to be Chantal in Bowe's life. So it was an easy decision to make to have Chantal do the direct of Bowe. Danay had forged a relationship with some of the witnesses, so we asked her to prepare for them. So we kind of do it that way. Usually I get the expert witnesses, I get to cross-examine them. And so we look at each other, we decide, okay, what's the strength, what's our weaknesses, and how does that match up to a task or a witness at trial? And then we make that decision.
Yeah.
Got it.
Yeah.
We don't have one set way of doing it.
Right.
It's fluid. It really just depends on, what we're getting, but it really is a team effort. And I think the bond that we have really helps us out in the long term.
Yeah.
Yeah,
Yeah.
definitely.
I think we were facing 36 motions in limine by
Right,
the defense, and then we had 22 or something. So it was just Daniel was on vacation.
On another,
Yeah.
another.
So we were like,
Cranking
you
them
take this
out.
one, I'll take this one.
But it was really a team effort. It was like, okay, I'm done. What do you need? I need help with this, and it worked out.
Yeah. And it varies on the case too, like depending on how we do things. Like if the motions in limine are manageable, then we might divide things up one way. If the motions in limine or pretrial motions or your scheduling order is really tight, then, sometimes somebody is working on the written work while somebody's doing the witnesses, prep, demonstratives, that kind of thing. But so that's why I was curious, because a lot of times we're in teams of 3 lawyers on trials. And so I was curious how y'all do it.
Now, one thing that we do for every trial is we do psychodrama before we start the trial to work and prepare our clients and for us to get to know our clients. So I'm always involved in the psychodrama along with both Danay and Chantal. So we always do psychodrama because that really helps you understand and connect with the people in your case. And surprisingly enough, even with the defendants, even though obviously they're not physically participating in our psychodrama, through the magic of psychodrama, we have them in the room with us. And we get a chance to get to know them. We get to know what rocks their boat. We get to know what's important to them, what isn't important to them. And so when we do cross-examination of them, we know what buttons to push.
Right. We pull the feelings out of that. And so I think that helps us in every aspect.
Well, it's just a fantastic job by you guys, and I'm sorry that some of the things didn't go your way, because it sounds like you guys are up on appeal now. So if you have to try it again, I wish you great luck on that. But is there anything else that we haven't talked about this case that you want to make sure that our listeners have heard?
Yeah, just kind of one point, and it's this. Unfortunately, tragically, now I'm using adverbs now, okay? School shootings have become the norm. And the surprising thing is they were always the norm. School shootings have been around. The first recorded school shooting in the United States was 1767 or something like that, before the signing of the Declaration of Independence. There have always been school shootings. But now through the magic of social media and so forth, we hear about a shooting in New Zealand. We know about it the instant it happens here. So it's not a recent development. And school districts have known about it and have come up with systems, but they don't follow them. So my point is, these kinds of shootings are preventable if you start holding school districts accountable so that they just don't pay lip service to their threat assessment.
Right.
And they actually follow them. So it takes a trial like this. For example, here locally, the school districts here, they always have threat assessment. Now they're taking them seriously, whereas before they didn't. So sometimes the work that we do as trial lawyers really does benefit and help the community, which at the end of the day is the most gratifying thing any one of us as a trial lawyer can do.
Yeah. No, that's absolutely right. And you know, and sometimes it is the, you know, have to put a defendant in a courtroom, have to hold them responsible that way for them to wake up and really do something about it. So, well, great job on this case, guys, and good luck on your appeal. I want to remind everybody that we've been talking to Daniel Rodriguez, Chantal Trujillo, and Danay Gonzalez from Rodriguez and Associates, and you can look them up at rodriguezlaw.net. That's rodriguezlaw.net. Thank you, guys. Thank you for your time.
Thank you.
Thank you.
Thanks, guys.
All right. Yeah, you stay safe too. Absolutely.
All right.